Good morning, fellow chiropractors, physical therapists, medical doctors, and attorneys that work in personal injury. Dr. Shetlin with the Whiplash Group here, and I want to go over a couple of very important upcoming things happening where Utah has been drawn, the battle lines are drawn here in Utah, and these tort reforms are trying to go nationwide to help lower the reimbursement of personal injury care, which of course is an area of specialty, to just Medicare or Medicaid rates, which is completely illogical. To say, hey, look, we're going to have a brain surgeon who's got all the certification get paid Medicare rates or lower than just the regular medical doctor would get, or chiropractors that specialize in this getting paid Medicaid rates, which it pretty much costs us to have these people come to our office. It's just not a viable business model nor legal model. So the Garner versus Norman 2025, I know that the trial lawyers, they're really working hard to reverse this in Utah, and I hope they can, because it's very harmful. And Rodriguez versus Died, also 2005 in Utah, battle lines are drawn where we're trying to set up, what they've done is they've taken away the right to value the case based on the case. They're saying, oh, look, if this person makes less money or they're on Medicaid or whatever, that's all that case is worth. So somebody who has Blue Cross or better insurance and makes more money, maybe their case is worth $100,000 because they have better insurance. Somebody on Medicaid or with no insurance or something, the case may be worth $10,000. It's just ridiculous how it's structured. The Rodriguez versus Diad also says that, hey, doctors, if you have a lien, then you're financially tied to this and the outcomes of this to get paid. So you are no longer a viable witness, which means that the attorneys are going to have to bring in third-party witnesses like myself or Jeff States or somebody who is an expert in personal injury to help now try to defend your bill. So there's a couple key things I want to point out for all of our members. And if somebody's listening to this that is not a Whiplash Group member, still pay attention. This is good stuff for you. I don't care what state you're in. I don't care what your thoughts are about your state association in chiropractic, PT, medical. You need to be a dues paying member of your state association because they help keep the legislation fair to protect your license and ability to practice the way you want. So that's step one. And in certain cases like this, you just need to step up and donate to help support their PAC fund to make sure that we're pushing back on these very unethical laws and rules that are being pushed through. Number two, for my chiropractic physicians, and this works for actually all the medical physicians, medical and chiropractic and PT, you should have a separate LLC set up for your personal injury cases and care, separate from cash and or major medical. Apples and oranges. You need to explain the No Surprises Act, where when you have a patient come in, regardless of cash or PI, you're explaining up front what your fees are. And if you're a specialist in personal injury and not just some self-proclaimed specialist, you actually have done certification and training, which I highly recommend all the time, but especially in cases like this, you're the only ones that are going to be protected or even partially shielded in cases like this. If you leverage the No Surprises Act and protect yourself by showing what your fees are, what the estimated number of visits a patient's going to need to come in for care based on your workup, diagnosis, treatment, research-based guidelines for personal injury or cash or whatever, and you show the fees and the care plan, what the totals are going to be, you've already set precedents in advance of this is what is expected, and the patient knows what they owe. That is a very important step. So separate LLCs for PI versus the other one, No Surprises Act with everybody. And if you're not using, and this is just for chiropractors, CUSA, the Chiropractic Health USA, using that system in your office to help separate when you have fees here for personal injury, because that's your specialty. And if it's not your specialty and you're charging more for personal injury, you already have a dual fee system. If your fee is your fee and you're charging extra for personal injury, that's against the law. You need to be a specialist in personal injury to charge higher rates for personal injury, and then you can have discount rates for your cash patients. So many docs are doing this wrong across the country. They're really setting themselves up with a target. So I'm going to say number three, certify. Get certified with the Whiplash Group or Personal Injury Training Institute. So you at least have some credentials to say, I am a standout expert in this field. Not, I took Croft 30 years ago. Croft is awesome. Don't get me wrong. It broke the mold on how to better treat and rehab and having the frequency and duration of care plan for injuries post-motor vehicle collision. Brilliant stuff. Hats off to Dr. Croft. But there weren't certification training tests at the end. And are you keeping current? Just because you sat in a seminar 10, 20, 30 years ago doesn't mean you're an expert in that. Experts are always updating and keeping current. So you want to get certified and you want to keep current by keep studying current things in the field of personal injury. For lien verbiage, I would talk to Michael Coates to make sure that you have an updated lien that clearly navigates that the patient owes the fees regardless of the outcome of the case, but the lien is passing some responsibility on to the attorneys. The patient has already signed paperwork in your office stating they know you work for them, not for the attorney or the insurance company doctors. You work for them. They owe the fee. You covered it in your initial paperwork. You went over it with them on day 2 with your No Surprises Act, making sure you clarified what was going on. You've done your work. In order to get paid and keep those values up there, you need to be a specialist. You need to have separate LLCs. You need to clarify the fees up front. And then on your lien, you have to have the right documentation. And then if you're a specialist and you're ever put on the stand, which if they're saying you have a lien and now you're not going to be able to even defend your own care or case in court without getting just pummeled because, oh, you're financially tied to the case, you need to understand the lien should have the right vocabulary, and you, doctors, need to know what to say on the stand. You need to say, the outcome of this case has nothing to do with me getting paid or not. The patient owes the fees that were discussed in the beginning. That's just what it is. Whether they win or lose this case, that's up to the attorneys to try to get that done, but that doesn't affect the fair exchange for your services being rendered as an expert in this field. So make sure you know how to defend what you do. Document things to defend what you do. Learn how to do that by getting certified. And if you don't have those skill sets, you're going to have to lean heavily on some very qualified and skilled attorneys in your state, or outsiders like myself and Jeff States and others that can defend you in court rather than you being able to defend yourself if you're not able to go to court because you have a lien. A lot of scary stuff that we're dealing with right now in 2025, 2026. So I hope this is helpful. Reach out with questions anytime. And good luck and God bless. Keep saving lives, doing what you do for our community.